So what do you do if the state dissolves your company? My name is Sam Bryant, and I help build and protect Florida businesses. So if the state of Florida has dissolved your company, it's mainly for one reason, and that reason is that you didn't pay your annual fees. When you register a business, you have to pay fees to the state every single year, and they give you a grace period. So if the time comes due to file your annual report and pay those fees, and you've exceeded the grace period, the state will send you a notice of dissolution. So what this basically means is the state is no longer recognizing your business as a legal entity in Florida. So if you're still conducting business after you receive this notice, then you're not operating within Florida law. So now, what do you do if you actually get this notice? If you want to remain in business, then you need to pay this fee. You'll pay a penalty, and it won't be much depending on when you actually pay it. So if you get the notice and you pay it immediately, then you'll pay your annual fee plus the late penalty. If you wait, so this is what happens with a few businesses. What they'll do is they won't pay the annual fee and then they'll sit on it and they'll wait a couple of years sometimes. So if that happens, it's not a matter of just simply paying a small annual fee plus a small penalty. What happens now is you have to pay the annual fee for every year that you missed, plus the upcoming annual fee, plus any other penalties. So that can really rack up for businesses if you get the notice of dissolution and you go 2, 3, 4 years without paying your annual fee. You end up paying hundreds of dollars just to get your business in good standing with the state. So that's if you want to remain in business. If you don't want to remain in business and you get this notice, a lot of times you can just keep the notice and just let the business lay dormant. If that happens, you just have to keep in mind that the name that you have for the business may be up for grabs. Um, Also, you have to be aware of creditors. If if you get this notice of dissolution, yes, the state has dissolved the company, but it still doesn't absolve you of taking care of your creditors. So if you get this notice of dissolution, just know that the state is no longer recognizing your business as a legal entity. But it can be reversed. So if you pay the applicable late fees, then the state will retract it and it will revert back to as if nothing ever happened. If you want to remain closed, then you can just keep the notice as is. You don't pay the state anything, but just recognize that you're no longer a Florida business, and you still have to take care of the creditors that you earned or that you've accumulated through the life of the business. So I hope you found that video helpful. If you have any questions about dissolution or if you've received this notice from the state of Florida and need help interpreting it or what your next steps could be, please feel free to contact me. You can use the links below. There's multiple ways to contact me, and I'll be happy to help. And hope you have a great one.